Okay, next we have problems with the JV when the relationship breaks down. JV relationships are becoming more and more commonplace in the construction, energy and infrastructure space. Companies don't want the financial or the risk exposure, or they're recognised as being specialists in certain disciplines and need somebody else to fill the gap. So joint ventures are becoming increasingly common in international projects. And although the EPC contract is often tightly drafted, not always, but often tightly drafted, arrangements between JV parties, as a general rule, can be less precise. And that's fine when the relationship and the project are going well, but as we all know, when things start to go wrong, parties rush to the agreements to understand their obligations, and any lack of precision in those obligations can act as a catalyst to a formal dispute. So this talk will examine risks arising from these arrangements, key features of these disputes and best practice. Chairing this session is Edward Shaw. Edward has 20 years experience of advising on construction, engineering and infrastructure disputes, whether by litigation, arbitration, adjudication, mediation or other types of dispute resolution, both in the UK and internationally. He routinely advises on major projects in the infrastructure, transport, power, energy, water and heavy engineering sectors, and has particular expertise in working for and advising Korean and Chinese clients, and has acted on disputes arising from projects in the Caribbean, the UK, Eastern Europe, Turkey, Africa and Asia. Edward is regularly praised in the legal directories within both the international arbitration and construction rankings, and I should say he forms part of the excellent team at DLO. Edward, can I hand over to you?
Yes, thank you very much, James. And I think with that introduction, I shall introduce my fellow panelists. So Shareena Edmonds, on my immediate right, is a partner at King & Spalding. Her practice is focused solely on international arbitration and the resolution of disputes arising out of major energy infrastructure projects. She has over 15 years experience of representing both owners and contracts, as well as representing clients in arbitrations. She provides strategic advice and acts as project counsel, assisting clients to manage and minimise risks on claim and disputes during the project execution stage. And then beyond Shareena, in my sense, is Tom Smith, who is a counsel at Hogan Lovells. He specialises in the resolution of disputes in construction in the construction and engineering field, and has acted in clients in all forms of dispute resolution proceedings, including adjudication, arbitration and litigation. And of particular note, I think, is the fact that Tom spent 3 years in-house with a Japanese heavy industries company and represented them in all aspects of their businesses. So having introduced my fellow panelists, as the background of this session, I thought I'd start with a short introduction as to why it is that JVs are so popular. And there, of course, are a number of reasons, but principally as projects become larger and more complex, especially when they're across jurisdictions in terms of the parties involved, they offer two or more businesses the opportunities to combine their expertise, finances and technology to deliver those large-scale projects while sharing the associated risks and rewards. And this can be for a number of reasons. It could be a commercial decision. It could be a practical necessity. It could be both of those things. It can also be required by local law. As a consequence of the scale of projects that we are seeing around the world, JV arrangements are increasingly common, and so much so that there are now talks that people in the audience may be aware of around standard form JV agreements. I'm aware of at least one that's in discussion at the moment, and I would imagine that there's scope for more. And I think with that in mind, it's worth briefly turning to the different JV consortium structures. One would be where there's a lead company, a prime contractor, where a subcontracting arrangement where that lead company backs off its own risk with the consortia or with subcontractors. So perhaps more of a subcontracting, main contracting arrangement, but nevertheless worth bearing in mind in the context. You can have an incorporated consortium, which is a separate legal entity, an SPV that is created where all members are shareholders of that SPV and they participate in the management of the SPV via their various shareholder rights. or you have an unincorporated consortium where no separate legal entity is established, but instead there are various forms of contractual cooperation around the sides of that, but not necessarily a shareholders agreement, albeit in that context the employer is likely to expect joint and several liability. But regardless of the reasons why a JV is entered into, they are rarely straightforward in my experience, and I think for the reasons we're going to discuss. And I did a little bit of research before this talk, and the statistics, which do come from a variety of sources, suggest that JVs are the source of approximately 30 to 40% of disputes within the construction and infrastructure sector. So with that as the background, and bearing in mind those statistics specifically, Shareena, could you talk about the bid stage, please, the pre-contract stage, and why you think that JVs give rise to so many disputes?
Sure, thanks very much, Ed. And I think it's important to reflect on that question from the very beginning so that parties can try and anticipate and do what they can to avoid those disputes. So, to my mind, I think there are a number of different factors at play, which together or in combination are making for quite a fertile environment for joint venture disputes, making those disputes more likely. Those factors include, first, the nature of international construction projects in this market, which you've touched on a little bit. Projects are getting larger. We're now regularly talking about the mega project, the giga project. They're getting more complex, more ambitious. We're seeing new and different technologies, very aggressive, ambitious schedules, very tight budgets. We're seeing companies coming together to work in joint venture for the first time together, perhaps undertaking the type of project they've never undertaken before in a new market or a new jurisdiction with a new owner. So that's the environment in which the joint venture is required to come together, to work together, to collaborate, to succeed and to deliver that project. It's obviously a very challenging environment. The second factor I want to highlight is for all the reasons you've given, we're seeing pairings, partnerships of companies from very different backgrounds, experiences, cultures, approaches. And again, those companies have got to cooperate, they've got to work together, they've got to achieve an alignment to deliver that project. So the dynamics of the joint venture are really important. Obviously, there is a fit, there is an alignment in one sense on the technical level, the skill set level, the experience level. There's a reason those parties, those companies have decided to tender for that project together. But to me, there's a need for broader alignment, broader thinking in terms of, is there a communal, a joined up thinking approach in terms of contracting, contract strategy, contract administration. Those projects are obviously not without risk, no matter what you've done in the negotiation phase to try and bring those risks down. Those risks will remain and they need to be managed by the joint venture contractor. What is the thinking? Is there an aligned thinking in terms of the approach to that contract administration where there isn't that alignment, where there is perhaps a clash of cultures, experiences, approaches? That again, to me, promotes the chances of a dispute. And one last factor I think is important to mention, and maybe this is a little bit unfair because we sit on the dispute side, so we only ever see the worst examples, but based on that experience, what we often see are joint venture agreements which aren't as carefully considered as they might be, which don't reflect real thinking, real drafting around what the partners are going to need to do, how they're going to do it, and if and when challenges come up, in this environment, how are the partners going to solve that? We're not seeing joint venture agreements which reflect that thinking. More typically, what we see is parties defaulting to something far more boilerplate, generic, a little bit vague, broad obligations around collaboration, in good faith, participation, assisting, support, which leaves a lot of grey and a lot of uncertainty. And again, to my mind, that promotes or that provides an environment where a dispute is more likely.
Thank you. And Tom, in line with Shareena's observations, what issues do you think JV parties should be alive to when at the negotiation stage and possibly earlier?
Well, actually picking up on a few things that Shareena's just said, that there's a reason why you're in a joint venture in the first place. It could be that you need your joint venture partners' technology, you might need their specific skill set or experience, their local knowledge of the market. You might need, financing or bonding through them. Or it might simply be a function of the sheer scale of the project that you're taking on, that you just simply need a partner to do it with. So the key question is, who is your partner? What do you know about them? You may well have worked with them before, but often in the current market, you may not. They may be new to you. You need to really do some proper due diligence at the outset. You need to know, look, do they have the capability to actually deliver the scope of work that you need them to do, particularly if you are going to be the actual or de facto leader of that JV? Are they financially stable? What security do you need from them to ensure their performance? And also, I think this is key, and I'm going to come back to this a bit later on, but how can you be sure that they're sufficiently committed to the project? Because, there's always a tension when you're at the bid stage between what's in the MOU. You're agreeing to collaborate, you want to get the bid documents, everybody's friendly, everybody's happy, maybe they need the project at that time. These negotiations last a long time. Are they still going to be committed at the end when it comes to it and when you're actually allocating the liability? And this is why you need to be thinking about these particular areas that I'm going to come on to early, and also maintain them in your mind throughout. So, key question, who's actually going to lead the JV? Not just who's going to lead the JV operationally, but who's going to run the negotiations with the owner or the employer? Factors to consider are who's just more, who's got the most experience or capability in that area, what's the kind of cultural fit with the owner. So those are things to bear in mind. You want to get the JV structure, whether that's incorporated JV or much more commonly an unincorporated JV, agreed early. You also need to agree the scope of each JV partner's risk or contribution, how the liability is going to be allocated. Is that just going to be done by scope price, or is there going to be some other issue? How are you going to manage interface risk? And who's going to be responsible for procuring the bonds or any other securities? And it's really important that these conversations take place in the context of a realistic understanding of how the risks are going to be allocated under the EPC agreement. So all parties need to be aware of, what clauses are going to be mandatory. You need to be talking together about what's likely to be bankable or not bankable. Don't assume knowledge of your JV partner that you have, because they may not have operated in this market or in this area before. And the reason that's an issue is because proceeding on the kind of basis of incorrect assumptions at the early phase is just a surefire recipe for disaster later. And this is particularly so in the context of the really large projects where we are now seeing one or more of the JV partners also having an investment stake in the owner. And at that stage, you get really kind of different kind of commitment levels between the different JV parties. So I think at this early stage, what you really need to be doing is thrashing out kind of the key risk kind of allocation and liability early, and then what you need to do is make sure that you don't just stick that in a kind of a non-binding MOU. You need to be negotiating, updating, agreeing the JV agreement as more and more information becomes available about the EPC. The one thing which we see a lot of, which causes a lot of grief and strife, is where negotiation of the EPC contract has got ahead of negotiation of how those risks are going to be allocated within the joint venture parties. And that, I think, is something to avoid for sure.
Thanks, Tom. And I think that's a really important point, which then takes us to the next stage, the execution phase of the project, where the sort of the tension of the operational aspects start to come to the fore, especially if those issues haven't been addressed properly. This is where the challenge of jointly delivering the project start to arise, and the interactions with the owner really start to kind of create an additional level of tension potentially. And the potential sources of challenge and dispute are many, and they include the contract delivery and technical disputes. So what is the JV's approach to variations going to be, extension of time claims, agreeing on appropriate design solutions for a particular issue, or concerns over the project manager that may have been seconded by one of the JV partners. There are issues arising from participation, cooperation, picking up on some of those themes, disagreement between the JV partners over how the project is being managed, or what either JV partners' responsibilities or obligations are under the JV agreement. And of course, there are financial concerns and issues where one party to the JV encounters financial difficulty, particularly in construction engineering projects where margins are as tight as they are. This can lead to non-payment of various things, materials, labour, whatever, but that can then cause delay to the completion of the works, and again, issues as with owner, but then between the JV parties. So again, Shareena, with that short sort of contextual introduction, what are your views and experiences of this stage of the project and the issues to be alive to?
Sure. I think this is the phase, the execution phase, and in particular, once problems and issues start to arise on a project, that the joint venture agreement is really going to be tested. And in my experience, this is where you see that grey, those gaps in terms of the thinking behind the agreement and what the agreement does not do in terms of helping the parties to understand their positions and how to resolve potential issues. So just a couple of examples of the kinds of problems which might arise in this phase, which the joint venture partners are going to have to resolve, or will look to the joint venture arrangements agreements to resolve. First example, the joint venture partners anticipate in the joint venture agreement putting in place a very detailed protocol procedure on exactly what payments are going to be made out to the partners for the sums and expenses they've incurred in executing the works, and how that process is going to be undertaken. Of course, that procedure is never agreed, and then later one partner takes issue with the nature of the amounts, the nature of the expenses, the sums being sought by the other partner. The second example, one partner is dissatisfied with the subcontracts being put in place by the other partner, or the orders with certain vendors. They're selecting subcontractors, vendors where they have a strong relationship. There's nothing wrong in that, but there's a question as to whether those subcontractors, those vendors, are the right ones, will be capable, competent, will deliver on the works. If I can move slightly along the spectrum in terms of the difficulty level of the kinds of problems which are presented in this phase, which the joint venture agreement has to try and help the parties solve, to a different example. During the engineering phase of the project, the owner, perhaps unsurprisingly, makes a number of comments on the design submittals. The design review and approval process takes a long time. One partner is sat there thinking, one partner on the contractor side is sat there thinking, this potentially, probably, is going to cause an impact in procurement and construction. When we later look at this, we're going to trace the problems back to this phase. We need to be giving a notice, providing particulars, writing the right correspondence. The other partner disagrees. We don't want to start the project off in this way. We want to build a strong relationship with the owner. We're at the early phase. I'm not sure there's going to be that delay. Let's just wait and see. So the parties disagree on how to deal with that issue. I'm going to flip it a little bit and give an example from the owner's side, which I don't think we've talked about yet. A project where there have been any number of issues and impacts. The contractor has been impacted in terms of its ability properly, timely, efficiently to undertake the works for lots of different reasons. Interface issues, proper chain capital C variations, other force majeure issues, a range of different problems which have caused problems on the project and got the project almost to a watershed moment where the parties need to kind of sit down, recognise where they are, what's happening and what they're going to do going forward. The problem is the contractor is struggling to get its arms around that problem, to work out and to, more importantly, demonstrate, substantiate why these events have caused the time and the cost which is being sought, and not an unusual problem. Here we get to the tension and the challenge between the partners, this time on the owner's side. One partner sits there thinking, we need to focus on this project. We need a project first mentality. We need to give the contractor a little bit of money, get them over the line, use this opportunity to draw a line in the sand, close out all of the issues. That's what we should be doing. The other partner disagrees, takes a very hard line and says, unless and until the contractor shows and proves this entitlement, we should not pay, we cannot pay, and we don't want to set that precedent. I've walked through those examples because I think they're really good examples of the kinds of problems that joint venture partners are going to look to the agreement or arrangement to help them to solve. And typically what they're going to find is the joint venture agreement won't talk about that level of detail or that minutiae of how the joint venture is going to work. So what they're left with is these general obligations. And what they're left with is the challenge of working out what does that provision, what does that obligation mean as it's drafted in this agreement with this governing law? What's my partner's obligation? Do I think I have a strong argument that they're failing in that at the moment? And most importantly, what can I do about it?
Well, and that is, of course, a thorny issue. But with Tom, again, following on from that, what are your thoughts as to the typical challenges and areas of dispute that sort of arise at this sort of stage that, you know, parties really need to focus on?
Well, I think Shareena's done a good job there at kind of flagging the kind of real issues that can arise in terms of culture and alignment among the kind of management of the different JV partners. Raising claims is a real trigger point, you know, as it is putting in notices. And kind of being aligned amongst your JV parties is key on that. But the real test of your joint venture agreement and really the strength of your whole relationship is when things go badly wrong. And obviously lots of things can go wrong, but there's two real issues I want to just touch on quickly, which is, what if your JV partner is simply not performing? Or worse, what if your JV partner is becoming insolvent, or you have real concerns about its financial viability? Those are huge challenges within the context of a JV. I mean, if you think about the insolvency one, if you did have an incorporated JV, which, you know, is not all that common, but if you did, you may find that the insolvency of one party may actually just trigger a termination right over the whole thing, which is an absolute disaster for you, or could well be, not if you want to exit the project for any other reason. But so when you've got these questions around JV partner performance or JV partner insolvency, you need to have the decision-making apparatus within the JV to take quick and effective decisions. You also need to have a kind of a penalty regime within JV agreement. How do you compel a non-performing party to actually, you know, pull its finger out and crack on with the works? So you'll want to make sure that there are specific rules around allocation of delay LDs, for example. You want to make sure that you've got sufficient leverage against them to really kind of force their performance. In particular, you need to have, and this is where the kind of early thinking and early planning comes in, you need to have taken care around how you manage things like interface risk. Because when you're trying to allocate LDs, you're going to have a real fight if somebody says, well, actually, you know, all of this delay in my scope is caused by a knock-on from your scope. And therefore, you need to know in advance what you're going to do in that situation. Who's going to have the final decision about how you allocate those LDs? And then in the extreme, when you actually need to either remove a joint venture party or that joint venture party is kind of becoming insolvent, what are you going to do then? If you've got a kind of a financially precarious JV partner, are you going to prop them up? Is it actually in your interest, in the interest of the joint venture as a whole, to try and kind of fund them, to maybe pay their subcontractors direct or the suppliers direct? And then how do you then reflect that? Is your joint venture agreement or the relationship you have sufficiently flexible to allow you to step in and kind of take on some of their obligations? And if you do need to terminate a joint venture partner or remove them from the joint venture, you know, have you thought about the process of that? And then what happens? So, for example, you will want to make sure that in an ideal world, an insolvent or exiting joint venture partner has an obligation to provide all of the documents, the project documents, any design work. You want to be able to take over their supply chain and subcontractors. You need to have a right to take over any materials they have on site. You want to have a right to use any equipment that they have on site. And that kind of thinking about things in the kind of worst case scenario, in the kind of, you know, almost like a prenuptial agreement, is the way you need to be thinking at the start, at the MOU phase, and before you even get into the JVA, when everything's rosy and everybody's getting on. And I think, bearing in mind the kind of the hovering threat around this, which is the biggest risk to you, is how far do things need to get before you come under the spotlight under your joint and several liability obligations and have to dig into your own pocket? And is it better to kind of stem some of that bleeding early rather than risk being on the hook for a larger share of the liability at the end?
This brings us to the area of disputes, our baby, as it were. But once disputes have escalated and they have started to formalise, become inevitable, that's obviously the sort of point of no return. But it is possible to try and reduce the tensions between the parties at that point in time. And I would say that the dispute resolution procedures in the JV agreement do need to help smooth out the sorts of issues that we've identified already, by providing a clear route to escalate the disputes, while at the same time being flexible and catering for a range of scenarios, negotiation or fast track ADR on the one hand, or even more formal and up to litigation arbitration where that's not possible. And again, with that in context of a short amount of time available, I think, Tom, what are your thoughts as just the key issues and provisions that JV parties need to consider in that context? Disputes within the JV partners are linked generally to disputes between the JV and the employer or owner. That will leave the JV partners in the kind of invidious position where you might need to take a conflicting position up against the employer, as you might do with your JV partner. Now, where things can get complicated is where you are taking legal advice in the context of a JV party and where the JV as a whole is taking advice. I think it's just worth flagging that it's very important that you get that legal advice addressed to the correct party, because there's a real risk that you could inadvertently waive privilege over a whole raft of advice that you have got about your own position that suddenly becomes available to your JV partners in the context of a dispute among yourselves. And I think just finally, before we move on to a Q&A, there's a real kind of issue on control of documentation in this circumstances. So, what common documents of the JV party has been producing, what is available to you in kind of putting together a claim and cooperating in a claim against the employer, and also what kind of documents do you not want to be sharing with your JV partners at this stage, and how do you kind of manage that information flow for the good of the JV, but also while keeping your own kind of best interests in mind? So I think we've finished, although we can go on, but it depends on the questions and answers we're to give.
Excellent, thank you. Again, the online delegates have been very active, so let me kick off with some questions. First question is from somebody called Morrow, and the question is, are alliance contracts disappearing? I think we can deal with that very shortly. The answer is probably no, but no, an open-ended question.
I would argue quite the opposite. It's an interesting one that is a developing area. Alliancing is different again to JVs, of course, because you bring in the owner as part of the process, so it's a separate concept, but I think it's an important one to raise. I think they're on the increase, personally. I think the model in Australia in particular has shown them to be very, very successful in bringing in significant projects on time or even ahead of time and under budget, which is a concept that many people are a bit alien to them. And interestingly, they started off, it was BP, I think, that introduced them conceptually in the 60s and 70s with the oil fields in the North Sea. So they do have their place globally. I think we're beginning to see them back in the UK for some of the UK projects, including utilities projects, so the waterworks projects that we're seeing. So I would say the opposite. I think they're on the increase.
Very good. Moving on, a number of questions, as I say. This question is from Tom G, who's from Hitachi ABB. Do you have any experience, whether good or bad, of the sorts of bridging agreements that are used between unincorporated JV members to manage the preparation, submission and determination of claims toward the ultimate customer? Any points that are key to include in such arrangements, for example, mechanism timing, dispute forum, disagreements as to entitlement between JV members? What about the use of claim buckets and separate liability caps on delays for respective scope and so on? Are there any experiences that the panel considers worth sharing?
I was, having fielded the last question, I was going to chuck my panel members under a bus and then see if they want to deal with it. Tom G, and I know exactly who you are, that's a typically insightful and difficult question. Either of you want to?
I have to admit, I've not actually had much experience of bridging agreements in that context. I mean, I think we could think about the kind of overarching things you might want to bear in mind in an agreement like that. So, you know, what documents are you going to look at? How are you going to bucket the claims? And I think, as you say, Tom, thinking about separate liability caps and almost trying to ring fence certain bits of the claim makes a lot of sense. The way you're going to do that is going to be, and I realise this sounds like a cop-out, the way you do that is going to be hugely fact-specific about the types of claims you're doing, what your joint venture agreement already says, and the particular context in which you're operating. I don't know whether anybody has any kind of thoughts about what other types of provisions you might want to have in those agreements.
I was just going to make a similar comment. Having said, look, it's really important joint venture partners really think about what they're getting themselves into, to plan for that, to contract for that. Obviously, I can't then criticise them for going into this kind of arrangement to try to do that very thing. I guess the only thing I would say is careful consideration needs to be given to how far you take it, how much detail you go into, because as you say, when you get there, it may be that you decide you want to do things a slightly different way, given the types of claims, the issues. The other thing I would say, based on my experience of bridging agreements, not in this context, but in another context, which seek to, as the name indicates, bridge across other agreements, is what you very often find is a lot of inconsistency between what is in the bridging agreement and here what is in the JVA and presumably also the EPC. So careful thought needs to be given to how those three things fit together, and that, I guess, brings to another point which I was going to raise actually when we talked about disputes, which is, I think, when clients think about joint venture disputes, sometimes what they focus on naturally is the joint venture agreement. What are those provisions? Where do I stand? What are my obligations? But of course, that agreement has to go hand in hand with the EPC. It has to, because that's what those rights, obligation, positions, etc. are relating to. So it's important to think about the joint venture agreement, the EPC, the governing laws of those contracts, which might not be the same, and now we're adding a third layer, which is the bridging agreement.
Thank you very much. We have a question from the in-person audience. Please state your name and question. Sorry, Edmonds, you speak up.
Is whether or not to arbitrate against the employer, and you mentioned about people that arbitrate on get the resolution, like whether without arbitration or arbitration. Picking up on that, if there's any scope where it's feasible to be agreed, being up otherwise, would arbitrate against the employer. Or is that the
Adrian Bell from CMS, do you think it's possible to agree in a prenup or otherwise to arbitrate against the employer or otherwise?
I mean, my own view is that starting an arbitration against an employer mid-project is always fraught with difficulty. Starting an arbitration amongst JV parties mid-project is even more fraught with difficulty. I would suggest that I suppose you can. Off the top of my head, I'm not thinking of any reason why you wouldn't be able to come up with a prenup, but there are, as you say, a range of circumstances and factors that sort of go to the types of disputes. So I suppose it's almost like a kind of something that we were going to talk about it a little bit around whether DABs were appropriate for a JV agreement, and there's an element of that which it crosses over, I think, because it's whether you can pre-agree the sorts of things that you may or may not push the button on at a particular point in time. And if it's a smallish technical issue that resolves and unlocks an impasse, then yes, you may want to do that, and you may be able to do that in a way that doesn't completely destroy the relationship with the employer, the owner. But there may be more fundamental long-term disputes, you know, like significant extension of time claims and the like, which require, okay, you've got to do your notices, which is a challenge, as we talked about, as to the timing and the content. But nevertheless, it's you know, that they are much more fact specific, and therefore, would you want to be doing that during the course of the project? Perhaps not. I don't think it's an absolute answer, but I think you possibly could. I don't know if...
Just conscious of time, there's quite a few questions.
Oh, really? Okay.
I was going to
we'll
add
just move on. One question, one person answering, just to try and get through all the questions. This is from Dom Moynihan. He says, I wholeheartedly support the panel's emphasis on planning for the worst and due diligence at the start. Particularly, JV partners need to be like-minded companies. If they are not, in my experience, the JV will not end well. I think that's a statement as opposed to a question. But a question from Ben. Do the panel have any practical tips from experience for dealing with inter-JV disputes from the perspective of advising one of the JV partners or alternatively the contractor? Maybe one of you can give one practical tip or one practical tip each.
I spoke last, so I'll hand over.
My practical tip, and this might not be a popular one because of cost, is I think where you are in a dispute with the owner and you have your team, your lawyers, etc., advising you of the position of the contractor capital C in that dispute, it is a good idea to have somebody advising you and having your back, almost looking after your interests as the joint venture partner, to make sure that nothing is done, said, etc., which is going to damage your position overall. Once that owner problem has been resolved and you come to look at your partner and try to get that issue resolved. As I say, that's something I would suggest, but I know it's not always something which would be welcome because of the costs involved.
Excellent, thank you. Time for just a couple more questions. This is an anonymous question. What are the options to introduce an independent management / dispute expert to drive the project, and to whom the partners are to take instruction?
I mean, it's certainly an option. It's not an option, I think, which is taken very often, and I think that's because you know, it seems quite extreme as a JV that you're kind of punting out some kind of real key conversations and discussions around your own relationship to an independent person, you know, notwithstanding whether you can actually agree on that independent person. And I think this actually circles back to what we were discussing as a group before this conference, which is, you know, would a DAB or something like that work in the context of a JV? And I think really it's very difficult to get along the line to the point where amongst yourselves in this kind of collaborative co-working environment, you're actually producing the kind of level of detail and claims against each other and having them kind of arbitered by an independent person. I think that actually can be a recipe for just further breakdown in the relationship between the JV partners, unless things, you know, have already got to that stage. But I'd be interested to hear anybody else's experience of an independent expert.
The only example I can have applies predominantly to incorporated JVs, where the parties have an entirely independent director that has no connection with either of the JVs, who has the casting vote and is the chair of the board, or however that's arranged. There's a cost implication to that. Thinking that through, I don't see why parties can't employ someone to be the kind of decision maker who, again, is independent for an unincorporated JV as well. But again, there's a cost implication. But those are my thoughts.
Right. Well, I'm so sorry.
I've no time.
I'm afraid we're well
Second
over
time, no problem.
More questions have come in than we've got time to answer. So to the online delegates, please fire your questions at Edward, Shareena and Tom. You'll find their contact details online, I'm sure. But please all thank Edward, Shareena and Tom for that very interesting session.